Uma Devi, your lordship, who couldn't trust, your lordships are held is a constructive notice.
Satwan Patel is an expert in this subject.
My lordship,
He knows that this has been explained by the Patel. Have you gone through Justice Qureshi's judgment?
Yes.
There he said that don't go only by the constructive notice. Sometimes you have to take a practical view of the matter. Party may not be aware. When you apply constructive notice, that is by a deeming fiction of law. But there may be cases where party...
Here, my lords, may I submit, my lords? Here he says, my lords,
show us something.
Yes.
Forget about the constructive.
On suit, my lords, may have...
Show us something.
Yes.
That he was aware of.
My lords, may I have page... His everments, page 10, and suit, my lords, may I just take your lordship to suit, my lords, his everments. It's first, my lords, may I have page 60...
Okay, have you gone through the recent pronouncement of this court authored by Justice Narasimha on constructive notice?
That's the Dalibel's judgment, my lords. That thereafter Uma Devi has been pronounced by Justice Dhulia. That's Dalibel.
What have they said about this constructive notice?
Yes, my lord. This is Uma Devi.
If we have to strictly go by the date of registration, then the suit is barred.
Lordship, this is bad. No, please take him, please. Lordship, please. Your lordship says...
You are questioning the sale deed on what ground?
No, they are questioning. I am not questioning. They are questioning. I am the defendant.
Sorry, you are the...
They said I had my right, which my predecessor's name has not been entered into the records in 1988. That is what their claim is. And that continued till registration of sale deed. Their predecessor's name was not entered into revenue records. That is their claim since 88. And his predecessor never raised an objection because...
You tell us.
Yes, my lords.
Who executed the sale deed?
My lords, his family members, the plaintiff's family members. His uncle is...
Who was the original owner of the property?
The grandfather, his grandfather, the plaintiff's grandfather.
It's an ancestral property.
It's an ancestral property.
No partition took place.
But that's the in 88 prior to, because then in 88 when there was a record mutation happened after the ancestral death, his name was purposefully left out. That we are not aware as to how it has been left out, because we came into picture in 2004 when we purchased. His name was purposefully left out. Therefore,
why does High Court say that no cause of action is made?
Therefore, may I request my lords to see that para 10 of the cause of action paragraph. If in the suit, my lords, page 67.
Annexure?
That would be, I'm sorry, my lords, just a minute. Annexure would be P2. P2 is the suit, my lords.
Beg your pardon?
Annexure P2 is the suit. And then in course of action has been mentioned in para 67, page 67, para 10.
Annexure?
P2, my lords. Annexure P2 is the suit. Internal page 67, it's a course of action. May I read the course of action portion first, my lords, and then we'll take to his averments as to how his name has been left out.
Paragraph?
Paragraph 10. The reasons for filing of the suits arise. Am I with my lords?
Yes.
Arise since the grandmother of the plaintiff Jasodabin Bhagwan Das died in 15/4/1987 without executing will codicils. Since the father of the plaintiff Kanubai Umiyabai Sankar died in 88. Since the defendant assembled and in their collusion created false documentary evidence like Pedinama, the reply of third party application, and on that basis they have got entered mutated revenue records and executed sale deed in 2004. So his name was left out in 88 itself.
What was the age of this?
He became major in 85. The plaintiff.
What is his name?
Sanjay and Jatin, the plaintiff's fathers.
And who is this Kanubai?
Kanubai is his father.
So after Kanubai passed away,
yes.
In what manner the revenue records came to be corrected?
Nothing has happened.
Kanubai's name was never reflected.
Was never reflected.
Why?
Because
Kanubai doesn't have a share in this process.
It appears that partition might have taken place prior thereto. We are not aware of it. We came into picture in 2004, but in revenue records since 88,
you are
it continued. Purchaser.
Purchase.
Purchaser. I purchased land in 2004. Sold it registered.
And the suit came to be instituted in
2022. 2004 it was registered. Possession handed over. I am in possession.
the further proceedings of, is it a regular
Civil suit, my lords.
regular civil
Page
suit number?
56. 436 of 2022, pending before Principal Senior Civil Judge, Ahmedabad Rural.
Shall remain state.
I'm so deeply.
Give them dusty.
I'm so deeply obliged.
May it please, my lords. My lords, there are two orders in the challenge over here, my lords. First is the amendment petition that we had filed regarding amendment of pleadings that was rejected because saying that there was a delay and delay was not explained. But we had brought forth the pleading that there was a fraud committed on the end and the vendor had no title or possession or right to sell this property. Second, my lords, we had filed a second appeal, which the Honorable High Court has stated that because a suit and a counterclaim was filed, two appeals were supposed to be filed and not one appeal. Our argument was because it is a consolidated decree, so therefore, my lords, one appeal was maintainable. My lords, there are 5 High Court judgments. 3 are saying that to a composite, a single appeal can be filed. While
Of amendment you wanted.
my lords, what had happened was the property, the vendor, he had no title on the property that he sold.
The suit is at what stage?
My lords, the suit has been disposed of. The appeal has been disposed of.
Right.
We went in the second appeal now. And in the second appeal, when we came to know about this fact, that was the 1954 judgment that I've annexed with the petition. My lords, I filed an amendment petition. That amendment was rejected because
Amendment of what?
of the my written statement before the trial court, my lords. We stated that because the vendor had no title, so therefore we stated that as he had no title.
Second appeals placing files now. For example,
We'll keep it on Monday. Somehow we have missed this one.
Obliged, ma'am.
But the suit came to be dismissed, now.
My lords, the suit came to be allowed, the counterclaim came to be dismissed. There will have to be filed a single appeal against both the orders.
Right.
The appellate court confirmed it. Now what happened was when we went to the High Court in the second appeal, the High Court stated that because you have not filed an appeal against a counterclaim, you have to file 2 appeals.
Correct.
Therefore, the res judicata comes into play.
Correct.
But my lords, our argument was that because it was a consolidated decree and a consolidated judgment, therefore one appeal is maintainable. My lords, there are different judgments before the High Court.
This has nothing to do with your plea to amend the written statement.
No, my lords, but there are 2 orders that have come into challenge. I have challenged both the orders because both the orders were passed on the same day. So therefore, I have to challenge both the orders, my lords. Yes, my lords, but it was as it was pronounced separately, so I have to challenge both the orders together, my lords.
But you come to this page 6. Just read this finding.
My lords, point 7.
Page 6, internal page 6, para 7. Much water has,
Much water is flown down the bridge.
it should not be flown, it should be flowed.
What's that is?
Water can't flow.
No, that's high.
Much water has
Flown down the bridge ever since.
ever since.
Since the state was
Estate was recorded in the name of the state government. The act's intermediary filed a suit being title suit number
50 to 93.
same was decreed by declaring the title of who? This decree never came to be challenged till date, and as such has become final. As argued by Mr. So-and-so, has not placed anything on record to show why the proposed amendment was not sought to be introduced earlier and is being attempted to be done at this belated stage. Any good reason for
My lords, our argument was that we did not discover this judgment of 1954 where this property was owned by the Raja of Patia. He had purchased it through an auction proceedings and therefore he had the right title and interest over
And on the strength of this, how will you defeat the claim of the...
My lords, we were saying that because he had no title, therefore the entire sale has to be cancelled. Whether it's for us or whether it's for them, the entire sale has to be cancelled
You
because
don't get anything,
No.
plaintiff doesn't get
No, my
anything.
lords.
Then land goes to whom?
to the estate of Raja of Patia, my lords.
Next Friday.
My lords, next Monday or Friday?
Friday.
Okay,
Which means yeah.
My lords, in item number 28, I beg to appear on behalf of respondent number 2, my lords. My lords, this is a MA suo motu which has been taken up by the court, my lords, for the depositing the amount.
So who appears for the petitioner today?
I am for the petitioner, my lord. We
Have
had
you
already
deposited
deposited.
this amount?
Yes, it's
5
wrong
lakh?
back, my lord. It is the respondent number 2 has not been providing the account details. That is why the amount could not be transferred to the account of the respondent number 2.
And who appears for respondent number?
My lords, I appear on behalf of respondent number 2, my lords. I appear virtually. I apologize that I...
So why are you not providing your account details?
My lords, we have been trying to establish contact with the client, but unfortunately, the number which we had is not available. And my lords, person is a very old man, so I am unfortunately I'm not able to establish any contact. In fact, I had informed the local council as well.
Supreme Court Special Lok Adalat. The following order was recorded, dated 29th of July 2024. Spoken. Sorry, just matter has come up before us today with the office report stating that the amount of rupees 5 lakh deposited by the petitioner in accordance with the settlement terms is now to be dispersed and released in favor of the respondent number 2, Jitendra Bera. But Shri Bera till this date has not furnished his account details or has not come forward to claim this amount of rupees 5. Mr. Shivam Kumar, learned counsel appearing for Mr. Bera would submit that he has no instructions from his client. We grant one last opportunity for the respondent number 2, Jitendra Bera, to furnish the necessary information as regards his bank account. Post it after 2 weeks.
Grateful, my lord.
May it please the Lordship, my lord. There are 2 appeals, my lord. There's a delay of 177 days, my lord. That is enumerated in page 185 of, my lord, one of the SLPs, my lord.
How do you propose to invoke arbitration?
My lord, on the
Signatory to the main agreement itself?
Yes, I admit. Now what I see is, my lord, that, my lord, the agreement was entered upon between the firm and the PPCL, my lord. There's no dispute with regard to, my lord, me being a partner, which is another agreement which I seek specific performance in a separate suit, my lord. I'm not seeking any relief with regard to that, my lord, against PPCL, my lord. Nobody is disputing. I'm sorry, my lord.
Page 4.
Yes, my lord. Of the imperial order, my lord. Yes.
Read the third paragraph. This court has to decide. Read it.
So it's seeing, my lord, section 11, the appeal from section 11, my lord, or the appeal from section 37, my lord. There are two appeals, my lord. One is from section 11 application, my lord. This other one from the division bench, my lord.
No, we are reading this order of the High Court. Dated 27th.
That's a single bench judgment. Yes, yes.
So just come to
Yes, my lord.
page 4,
Yes, my lord.
internal page 4.
Yes, yes, my lord.
The third paragraph. This is what we have understood. This court has to decide whether the petitioners, non-signatory to the memorandum of agreement,
Yes, my lord.
dispensing pump and selling license stated, can invoke the arbitration clause and approach this court for appointment of arbitrator in terms of clause 19 of the said agreement.
Yes, my lord.
Then it says further, it appears that there was an agreement between the petitioners and partners of Ambika Service Station. When the petitioner came to know that another agreement had been signed by the partners with a third party, a suit was filed. This is all okay. Internal disputes.
Yes, sir.
But then, how do you say that I have a dispute with BPCL and therefore appoint an arbitration?
No, my lord. My right with regard to, there are two things, my lord, needs to be taken into account, my lord. I was undisputedly in control of the business from 2015 till 2022, my lord. For 7 years, my lord. There are documents, my lord, when the application in section 9 was allowed, my lord. And
Original agreement.
yes, my lord.
Sure.
The agreement between the partners or the agreement between BPCL? BPCL, yes, my lord.
Today you want to drag BPCL into arbitration.
Yes,
Take us to that.
yes, my lord. Lordship is kindly take, my lord, the page 27, my lord,
Sure.
P1, my lord.
Now, just say
I'm sorry, my lord. P2, sorry. I'm sorry, page 33, my lord. I'm sorry. P2, page 33, my lord. As a licensing agreement.
it is between Bharat
Petroleum, yes. Yes.
and
In the and, my lord, in case of a firm, I'm on 2, my lord, and 1 in case of an individual, I'm not on that, my lord. I'm on the other one, my lord. In case of a firm, the present members of the said firm and any other members or member for the time being of the said firm there and each of their heirs, executors or administrators. I'm on this aspect, my lord. There, my lord, may I hand over one copy, my lord? There's the original one, my lord. While typing it out, my lord, the handwritten portions were, my lord, omitted, my lord.
he signed this agreement.
Agreement was signed by the erstwhile the respondents in the suit, my lord, who are the original partners, my lord. We were inducted in 2015, my lord. We were inducted in 2015, my lord.
Who inducted you?
My lord, the original partners, not BPCL.
BPCL recognized you at any point of time.
That was the original dispute. That was no.
It's the end of the matter.
No.
It's the end of the matter. Then how do you say that I want to go for arbitration?
Well,
Dismiss next matter. Next matter. What is this?
Lordship, this is a 302 criminal appeal. Trial court has convicted for life to 3 accused persons. High court reversed it and acquitted them.
On what ground?
Lordship, the High Court says that the statement of the injured, there are 4 injured eyewitnesses. Grateful.
Please, Your Lordship, I appear for the petitioner state
The Honorable High Court against the appeal against conviction under 302 converts it to 304 part 2. However, the findings are contradictory. If your Lordship sees page 38,
What are the injuries?
injuries are at page 35.
Annexure?
It's in the impugned order itself, Your Lordship. Page 32,
What is the weapon used?
iron rod,
Which part of the body?
head,
How many blows?
1 blow.
The genesis of the occurrence? How did the incident occur?
So, Your Lordship, these, there were 4 family members.
You said page number?
Page number 32 are the injuries that are reproduced by the Honorable High Court.
Internal page.
Yes, Your Lordship. SLP paper book, page 32.
Okay, come to para 34.
Yes, Your Lordship.
Dr. Sachin
Yes, Your Lordship.
conducted the postmortem.
Yes, Your Lordship.
Obliquely placed linear sutured wound, so and so, so and so, so and so.
May I only submit, Your Lordship, there is no dispute about the incident as such. The Honorable High Court converts it, saying that, I'm sorry.
Absurd, absurd, absolutely absurd, absurd. Notice issue कीजिए. We'll have to remand it. This is not 304. This is not 304. Perhaps this is not even 304 part 1. This doesn't
302.
fall within any one of the exceptions also.
Absolutely.
Bombay High Court? Strange. Dusty de dijiye.
Highly obliged. 31.1 is also connected. Ma'am.
Same.
Grateful.
Your Lordships put to me last time, it's a reduction of interest. And therefore, my Lord, I want to answer 2 points.
Have we passed some order in the past?
No, my Lord, it's a fresh matter. Kindly see page 7. My Lord, my concern is this.
I have something to say, my lord. So day before yesterday, matter got listed. My lords directed them to file additional document because this is bereft of documents. Now they have midnight, my lord. They have filed certain documents. We don't have a copy.
Okay, Friday week.
Yes.
My Lord, my apologies. It's a mistake of our part. It's a mistake on our part, my Lord. My apologies.
Accommodating him.
That's all right, my Lord. My apologies to him and to the bench.
You may be served on.
We'll do that. You should have filed it.
I would like to also see the states I made. It is blowing to smithereens 12A and my Lord Justice Padiwala's judgment a few days ago. It's smithereens. And if I'm exaggerating, your worship should not accept my submission. Just kindly see what is happening here.
That premeditation,
12A, well, is that 12A? I mean, your lordship may repeal 12A if this kind of conduct. Kindly hand over the other one to my Lord Justice Padiwala. Just give me 2 minutes on this. No, just 2 minutes on this. I've had it made specially so it's faster and easier. Whereas I am petitioner, he is a respondent, he is fighting me on some iron ore, saying that this is his, I have sold it to him, etc. That's the merit. That's not relevant. Just come to item, well, it's 3. Does my Lord have it, Malas? I, Malas, challenge a suspension order passed against me by the collector who stays it. I filed, Malas, in number 4, a police protection writ. Don't you got the number? Now the police protection is because miscreants, which means him, are against me. Let us kindly follow that for a bit. It will be a little interesting, Your Worship, how you can avoid 12A. It's very extraordinary case for us. Then he files an IA number in item number 5, intervening in my police protection writ in item 5, which is 2024, March. That IA does not seek any stay, no urgency. I hope I'm clear. That is dismissed in Malas number 6, his IA. This is in March 24. On intervention IA without seeking a stay, because today he says I want extreme urgency, waive 12A and give me stay. He doesn't seek any stay then.
what type of...
His stay is that I should not sell, touch or deal with the iron ore.
You should.
I should not. This he could have sought from number 5. Just see 5.
What are your business relations?
My business relations is that I never agreed to sell to him. He has filed a specific performance suit. It's just coming in 2 minutes. Just bear with me. A lot of you will be a little shocked about 12A. Now, Melissa, my point in number 5 is that this the Lord author a judgment, but the Lordship will see how the judgment is blown to smithereens.
Dr. Singh, would it not depend on the facts of each case?
That's the facts. These facts are the most perverse facts ever imaginable.
There is an urgency.
Yeah.
Court may assign reason.
Absolutely. No. So I start with number 5, where he could have sought urgency and stay. He did not.
One thing. Tell us.
Yes.
Exactly what is the dispute?
The dispute is a specific performance suit he files after 16 months of starting all this, in which he says that there is one exemption and one order 39. Two things. The exemption is from 12A, his suit. He's the plaintiff.
He is seeking specific performance
Of an alleged agreement
What is the nature of
by which I have to sell to him the ore.
You are procuring ore by mining? You are undertaking mining operation?
Yes.
So whatever you excavate, you have to sell that ore
To him.
That's your understanding.
That's the original suit for specific performance, which is filed 16 months after number 5.
Fine.
In that he says, I want order 39 interim injunction
Correct.
and waiver of 12A.
Right. Your argument is,
Yes.
it would apply if parties must go for mediation and resolve.
Yes.
That's your argument.
And Malas, the argument is that 12A in the commercial court context was introduced.
Now, if he is able to secure that particular relief which he is seeking, you may be able to excavate, but you cannot sell it to some other party. That is your problem.
He has got a stay after 2 years,
So
pretending urgency about non-sale.
we are just trying to understand the implication.
So the stay is
So either you have to stop the operations,
Or
you
not
don't
sell.
have to excavate,
Or not sell.
Or if you excavate, you have to keep that entire thing over there only.
Correct.
That's the thing.
I'm grateful.
But y'all can't sit and trash it out.
Not for the reason, just whereas your lordship will just for more as an example of litigation, this is very interesting, not for this case. 5 minutes will be very interesting for your lordships. Lordship will decide whatever. Because your lordship will not have seen these facts. Just bear with me for just 5 minutes by the clock. I've got this list, it's made for that reason. So item 5, he intervenes in my police protection writ, does not seek stay, seeks no urgency. Right, Bruce? 5 is March 24. 6 is his IA for intervention without a stay is dismissed. Then come to Malas, item 9. I'm not reading all of it, Malas. 9. He then attacks me asking the collector to recall the order. This is the second time he could have sought mediation or any interim relief. This is now in July 24. In item 10, he files another IA again for intervention without stay in July 24 in my writ. Copy to him now. You understand? No, it's a review petition. His order is passed in review.
He wants to defend his on the premise that the suit still cannot proceed.
And that too.
Client of Mr. Subramaniam has not been able to get any order. No,
He got a stay. After a review petition, in a review petition against an order where he himself lost,
okay.
which attained finality.
This order,
Yes.
you have not challenged further?
No, that is a merits order. I will challenge it on merits. I've still got 90 days.
Today-
I am only on 12A.
So your argument would be that because of 12A, his injunction application should not have been entertained.
Was dismissed. The trial court returned the plaint. Against that, after 1.5 years, he goes in a review. The review court doesn't have an application for stay, doesn't have an application for anything. In that review IA, he files and gets an order contrary to an earlier order by the same court which had dismissed him, which he had not challenged. Give me these dates have to be seen. Whereas the Lordship will just spend less than 5 minutes, the Lordship will allow me to go on the.
My brother's question is if 31.7 is the return of claim,
Yes, now so let's
pending in
Can I just kindly?
You got your point.
No, come to 15. Well, just one page will be left. Come to 15. Justice Padiwala will take number 15.
It is a suit.
That is his suit in which he has today now got a stay without 12A.
That is by the 711 order according to.
Yes, but Malas, this suit is filed after 16 months of the agreement, and it is filed, Malas, after all the earlier writ petitions where he is intervened over 1 year. Now come to 16. Returned suit, returned the plaint. My Lord has got, Justice Padiwala has got. Malas, one more thing, Your Lordship in 12A has said it is not a formality. Everybody will pretend urgency. It doesn't mean that if I file a 39, order 39, 12A gets waived. Everybody has read 39. Then, Malas, this order, there are important dates, fellows. 17, he challenges the order by filing an FA. This is very, very important. My Lord has got 17. My learned friend's suit is returned in 16. In 17, he files the first appeal. On 18, the order is reserved. On 20, the High Court rejects his interim relief. Would my Lord double tick 20, Malas? Would my Lord double tick 20? 14th of August, his interim relief is rejected. All this while he has not complied with 12A.
Points for you to vacate that 711 order or not. But then.
No, all this while he's not at 12A. Now just what he sees. In Malas, he challenges an item 23 by filing a review petition in 23. In this review, he has filed against an IA dismissing intervention. This is a little serious. In 21, he files yet another IA in my writ. Justice Padiwala have 21 months.
Yes, Dr. Singh,
These facts are very important.
come to para 42 of the impugned order of the High Court.
Yes.
Page 15.
Yes, fellas.
Let's read 41 also. We may note that by order dated so and so in review petition,
This court directed that status quo shall be maintained by order dated 9/1. So therefore, was
by order dated by
permitted to withdraw the review. Liberty was granted to pursue its remedy in the present appeal, and the interim protection is extended. But that is why Your Lordship will leave this for a minute. Just trust me for 2 minutes. Just see the list of dates. Three dates. Then I'll not press it because brother, this is not clear. Just bear with me, fellas. Your Lordship got 16. My Lordship Padiwala has got 16. Your plaint is returned for lack of 12A. I hope I'm clear. Then, Malas, he challenges it and orders for interim are reserved at 18. The very same interim he's got now is reserved at 18. My Lord has got that?
reserve.
The judge.
After it is returned, there is a question of reserve.
No, in appeal court. The trial court returns it. He goes to appeal. In the appeal, it is reserved at 18. He is denied and dismissed in 20. Mark that very important 14th of August. Dismissed. He does not challenge this.
In 24.
No, 20. That's the catch.
Give the serial number.
No. Oh, I'm very sorry. My apology. I made it for convenience. That's all. I should have said so. I thought Your Lordship.
Yeah.
No wonder Your Lordship might be disoriented if I'm saying. Well, it's 14th August 24. I hope I'm clear, Wallace. You have dismissed the interim application in appeal. You don't challenge it. Then, Wallace, he files this is extraordinary, Wallace. In 21, he files an IA 10875. In my separate writ, asking for protection. I hope I'm clear. This is my writ. This IA has no stay. It's only for intervention. That order of item 2020 and 21. In 21, his IA is dismissed for intervention. He challenges that in item 23. For intervention, he challenges by filing a review. So it's a review of a non-intervention order. I hope I'm clear, Wallace. In that order, High Court passes first and status quo. How? I'm asking myself in 24. No interim relief is sought by him. No parade. And it is passed contrary to 14th of August, where he has lost the main appeal. No, 1 minute more. He withdraws the review. There are 25. Well, Alison Mandel and Curator is not the right word here. He withdraws despite withdrawing a review of a non-intervention, he gets an extension of status quo. I hope I'm clear.
Yes.
Then in 26, the status quo is second time extended.
Converted to FA status.
In what? In a review against a non-intervention. And then comes the impugned order on the next page. Now, Maras, bear with me, the errors. So this is, Maras, because your Lordship has said, just turn to your Lordship judgment for a minute. Barring 2 paragraphs, Maras, all of the judgment has to be seen. Kindly turn to your Lordship judgment. Very recent judgment. I am not citing it because Justice Padiwala is the author. It considers all the law at one place. It's called Dhanbad. Please give it.
What may I adopt?
No, just 2 minutes, Maras. Today I am in appeal on a 12A. My Lord has said what happens, Maras, when I file a suit. If I file 39-1, the law is not that every 39-1 is urgent. So why have 12A? Why have 12A, Malas? Your Lordship has, Malas, punctured that theory in this judgment, which is blown to smithereens. Please see that now. Just bear with me for this. Kindly hand it over to copies. Just turn to para 62. He's try again, he gets some relief in a review. Does my Lord have 62? May I? Please turn to my Lord's conclusions at 62. Everything is summarized at one place. May I read with my Lord's permission? Conclusion.
Really?
The decision of this court in Patil is cited by the impugned order, lays down the correct position as regards 12A, holding it mandatory. 2. Para 104 of Patil, the declaration of mandatory nature relates back to the date of the amending act. 3. Para so-and-so of Patil, any suit which is instituted under 2015 without complying is liable to be rejected under Order 7. Not necessary here, but the Lordship has gone that far. However, this declaration applies prospectively. We are a prospective suit for us. A suit which contemplates urgent relief may be filed without first resorting. No problem. Not in these facts. Then come to E. Unlike 82, leave the court is not required. Forget that. So D is Balas. General principle. E can be ignored. F. The test for urgent interim relief is if on the examination of the nature and subject matter of the suit and the cause of action, the prayer for urgent interim relief by the plaintiff could be said to be contemplable when the matter is seen from the standpoint. This man is going on from March 24. He gets this in 25, 1.5 years later. He can't go to mediation. Then, Malas, courts must also be wary that urgent interim relief must not be unfounded excuse by the plaintiff to bypass. My Lord has used the word camouflage in the body of the judgment. Then even if the urgent relief ultimately comes to be denied, the suit may be proceeded with without compliance if the urgent is satisfied, notwithstanding the actual outcome of the merits. Now, Malas, the Lordship is given I. This is very important. I. Suits without complying with 12A prior to August cannot be rejected under 7. We are not that, Malas. Come to J. My Lord has got them? We are J. In suits without complying with 12A prior to 28, which are kept pending adjudication before the trial court, the court shall keep the suit in abeyance and refer the parties to time-bound mediation in accordance with section 12A if an objection is raised by the defendant by filing an application. Thus the answer, now read 63 also, Malas. If the suit is instituted on or after the date of Patil without complying with 12A, it must meet with rejection either suo motu or by an application, even suo motu. Next, B. If the suit is instituted prior to 20 without complying, we are not concerned with that particular one. Having answered, we find it difficult to accept the contention. This is para 64 on the merits of that case. Trial court as well as the High Court committed an error in refusing to reject the plaint under 711. On the contrary, the approach adopted by High Court in the impugned order in keeping the suit in abeyance and referring the parties strikes a perfect balance between the mandatory nature as well as. Now, Malas, this list of dates starts in March 24. You have no time to do mediation. And you get an interim order after, Malas, sorry to repeat, I end in 2 minutes, Malas. After your Lordships, why do you take away my people? After, Malas, your Lordship gets a refusal of interim relief in item 20. Just turn to 20. 20 is not challenged by you. Item 20. Advantage of his fruits of 12A violation. Just see 131. No, 1 minute, Mamas. 131. What is the application your Lordship is facing? This is the way you exempt 131. Just see, this is exemption he seeks. If this is so, I repeat, you might as well repeal 12A 131. Annexure. It's a paper book, page 131. Where is the annexure number?
Dr. Singhi, you first placed that 711 order here in a review against a rejection of an intervention. That is supposed to you placed that order.
Yes.
It's an additional document.
Yes. After 1 minute, 131 will my lord see. Just for a minute, if lordship doesn't mind. Kindly see 131 for just 1 minute in the main volume. The main volume, no? Just see what is the main volume for 150. This is not the way you can get an exemption, Malas.
Yes.
131.
Yes.
Delightfully vague, one page, 1.5 pages. Filed a commercial suit. Craves leave. Prays the plaint will be kindly read. Bent on dishonoring. Continually violating the agreement, clandestinely transporting. This is happening for 1.5 years. Clandestine transport. Then, whereas in case the defendant succeeds in achieving his illegal designs, forcibly ousting and unjustly enriching the lawful belongs to plaintiff, plaintiff will suffer an irreparable loss which cannot be compensated. Due to the urgent nature, please, whereas give up 12A.
Now, where is the order on this? First order on this?
Yes, the first order on this, fellas, in the suit is 14.8. Come to page 34. I'm sorry, 223. Apologies. 223. This is the first time. So, the first order is 166 when the plaint is returned.
P19.
Yes. So, just for correctness, the first order is page 166 when the trial court rightly returns the plaint. I hope I'm clear.
After this application was filed.
Yes. He returns it. The trial court gets it right according to me. He returns it. Now he files an appeal. In appeal, the order he gets is 223. Show me 223.
You notice on payment of process fee.
No stay. Issue notice. There are 3 issue notices on 224. Turn the page. List after 4 weeks. No interim stay given.
Understood. Then what happens?
Then, Wallace, he files an IA in item 21. Keep my list of dates open. It'll be easier. In my writ for protection from police, this IA 108, page 34 of the second volume, page 34, is for only intervention without stay. My learned friend, Mr. Gopal Subramanian's client, seeks intervention in my writ for police protection, no stay sought. On this, Wallace, then he files a review petition at page 230. Turn to 230.
Annexure.
Well, this is page 2, annexure number. Why don't you give annexure numbers here?
21. Annexure.
P21. P21. 230. Now in this, Wallace,
This review is against which order?
against item 20.
Show us that order.
Yes, order is 223, page number.
P19.
Annexure P19. The one you just now saw, issue notice. Now against this, he files a review in an intervention application which is dismissed. Well, I'm sorry, I didn't show the dismissal. The dismissal is page 34 of the second volume.
So after P19,
Yes.
there was a final order of dismissal.
No, P19 was the notice.
Then what happened?
Then he filed Wallace item 21A IA in my writ for protection, police protection, where the prayer at page 34 of volume 2 is of the IA is that please allow me to intervene. This order your lordship must read for 2 minutes. The date of this order is please 14th August. There are 2 14th August. My lordship may get confused. Second volume, additional documents. This is a very interesting order.
P?
The second volume.
7. P4. Yes.
So this second order, 14th August, in my writ petition, page 34, my lord has got. Now just turn it 34 straight away to, well, I'll not read the rest. The whole thing is summarized. So it's a detailed order. This fight is between me and the government about police protection. The learned judge had come to 46. After hearing,
Yes.
just see 8, para 8. During the course of arguments, learned counsel for the appellant, assisted by counsel for the proposed interview, is opposed. After hearing learned counsel, we have the considered views, security is a dynamic process, leave that. Now come to 47, where he deals with Mr. Subramanian's client. Page 47, para 10. Page 47, para 10.
Yes.
Since the middle of that para, since the proposed intervener has already filed commercial suit and after dismissal thereof, he has filed first appeal, which is pending in the High Court after issuance of notice. Therefore, proposed intervener shall be at liberty to pursue its legal remedy in the pending appeal, which he did not challenge, the other 14th August order. He never challenged it in Supreme Court or elsewhere. In the aforesaid pending first appeal, the enforcement of agreement by means of suit for specific, wherein the commercial code at the threshold of 711 has dismissed the commercial suit on the ground of non-compliance, etc. For the reasons recorded, this writ is disposed of. And then they dispose it off. So
Review in this order.
now in this, against this order, I will not intervene you, Mr. Subramaniam. He files a review. That order is passed, in review. Now just this review is important. Turn to 230. 230 of the first volume. 230 of the first volume. Give me what I'm asking for. 230 of the first volume. There is no prayer for interim relief. Just turn to 230.
Annexure.
230, annexure P21. I wonder if the Lordship has dealt with how many reviews of an intervention being denied. It's an extraordinary situation,
Right.
very lawyer friendly but very illegal. 230, he files this. And then, this is the whole petition. My learned friend is checked up. There is no application for interim relief. I can't show a negative. My lord will take my word for. See the index.
Where is the final order?
Now, on this, first order is page 50 of the second volume, the thinner volume, of the IA volume.
Why can't you all put it in a chronology? Additional May.
This creates a problem, but the thing is that
How many times we have to keep switching over?
just keep two volumes, I'm sorry. Sir. On this, the order passes 50. No, you have to put in the same SLP volume.
In the additional?
Yeah, in the second volume. Only two others. P5.
P5.
Now, in this, which is in a review of an intervention, the court is saying, file reply, etc. And last sentence, without any reason.
What did you do with
at
this?
page 57.
But what did you do with this?
I'll tell you. Page 57.
Got it.
Now he withdraws this. My learned friend withdraws it. Come to that order at page 58 of volume 1. I'm very sorry to.
So with the withdrawal, the order of status quo also goes?
No. I withdraw, but extend it. Then he goes to that the first appeal and gets the impugned order. And all this is without 12A. Well, at the moment, I'm not on merits.
Okay.
Will your lordships allow with this application of exemption of two lines?
Now we have understood. Yes.
Lord, may I? My lord, would your lordships kindly come to page 204, my lord?
With all due respect
Yes.
to the two learned judges,
Yes.
we don't have proofs.
My lord, may I just give a little context if your lordship does?
We smack off something very foul in this.
Try.
Very foul.
My lord, may I?
That's the feeling, unfortunately, we have gathered. Issue notice. Who is the AOR? Who is the AOR?
Mr. Amit Sharma, my lord.
That is so-and-so, the advocate on record. Waive service of notice for and on behalf of the respondents. Huh?
He's one.
One respondent. So,
Respondent number one. Who is respondent number two? Who are the other respondents?
Individual ex-directors are all the other respondents. Some support me, some support him.
We should give them dusty so far as
Yes,
officers
we'll
are
do that.
concerned. Right?
Well, stay of page 15, para 43.
so Lord,
Stay of
may I
page 15, para
make
43.
one submission, my lord, on that?
He cannot enjoy the
Lord,
benefits
may
of
I
his
make one submission?
Not be are we not granting you the final relief?
I'll tell you why not. For 1.5 years, he did not have para 43 at page 15. So why today, he has got it by repeatedly going round and round?
Thoroughly understood. No doubt about it. Thoroughly understood.
Your lordship is not bound by something which he goes and gets surreptitiously after 1.5 years without going 12A. If nothing happened for 1.5 years, why could he not have got this?
May I speak? May I make one submission? My lord, under the contract, he was supposed to supply me with 170,000 tons of iron ore.
Sir,
And I have paid the money, my lord.
sir, we are not going to touch your contract. What whatever may be the understanding between the parties, if each party is obliged to abide by it, they have to. But what has been highlighted is something which...
My lord, the injunction which he is appealing against is only to preserve, my lord, my rights under the contract. Your lordships refer to
bench
27.
takes that order in review and passes this.
No, my lord, just give me one moment. My lord, I need to offer some explanation. My lord, one explanation is, my lord, what he did was, after the agreement was entered, I paid him 1 crore of rupees the very next day. In terms of the agreement, the ownership of this 170,000 metric tons of iron vested in me. In order to, my lord, defeat my rights under the contract, he filed successive writ petitions in the High Court, seeking various so-called protective orders and of police protection to enable transportation of all this iron ore elsewhere.
No original agreement, we dispute the agreement. So 24 till now, you never had it. Why should you have it now? He did not have any protection from March 24 till August for the first time he got. And no reason given here. No reason given here.
We have a proposal. Would you all like to go before any arbitrator and resolve it? Tell us. We'll send you all to a good arbitrator.
Say no and get dismissed.
Finished it off.
Get dismissed. But he has filed criminal actions against me.
We'll take care of it.
That has to be. Then I think yes. Or a good mediator also, whether there's a lot you would want. Mr.
Will your client agree?
I'll persuade my client. I'll persuade my client.
You're getting something you want to
So no suit, nothing. No suit, no 12A, everything will go.
But this criminal must go, because he's filing left, right and center and writing to the collector. Stop me.
Lord, I need this quantity to be protected.
Parties to maintain status quo.
Great.
Both sides will maintain status quo. Both sides.
In all proceedings, in other matters, because all this is, he is filing so many criminal matters.
Parties are directed to maintain status quo as on date. If there are any other criminal proceedings,
there are
with the parties, all those proceedings shall also remain stately. Are you agreeable, sir?
My Lord, I am agreeable. I want this contract.
Okay.
It's only about a contract.
Okay, will you
I have paid the money.
Name one arbitrator. Sole arbitrator.
Part of the arbitration.
We'll put an end here only today itself.
Well, our case is that he doesn't have the original of the agreement at all. So it's all will go before the arbitration. Why do you repeat?
That's a different thing.
Yeah, that's the merit for us. My lord is right. Give a name.
Not the next day, 1 crore went in a bank statement.
Give a name. Well, it's a. Take the orders and leave the name blank. Somebody will come and tell the court master. I don't want to take it without there. Otherwise, anybody is retired learned judge of the Supreme Court, sole arbitrator. Give a name, any name. I forget the name. So retired now.
What are the stakes involved here? What are the stakes?
According to us, the agreement is not an original, not signed, not produced. Therefore, the stakes are for me. My entire mining will be stopped.
So should it be
There was a claim for specific performance.
Mediation is better, mediation is better because that was the intention, and thereafter, we go into the suit. Then let this 2 points, let the majesty of the law be followed in 12A. Well, let the majesty of the law be followed in 12A. That will be done through Justice Korean Joseph, through Mr. Panchu Gopal, anybody your lordship likes to nominate. And it will be hardly plus 8 weeks, etc.
Mediation.
Mediation. And that's right. That will comply with 12A also. Matter will be over either way.
Will appoint Justice D.Y. Chandrachud, Dr. D.Y. Chandrachud.
Certainly.
Former Chief Justice.
Certainly.
Should we pass the order?
Yes. Yes. Mediation. You not should use the word mediation. Can't be given. You just put it. You can't say.
And my lord, may I be implored that your lordship's order status quo ante. Great.
What would you say it with?
This mediation arises from the order passed by the High Court of Madhya Pradesh
Give us via media that you would
and
say something.
dated 11th of August
Give us via media that you would
2025.
say something till the date of the mediation.
In first appeal number 1150 of 2024,
Then may I take your lordship leave this?
by which the appeal filed by the respondents herein against the order dated 31/7/2024 passed by the Commercial Court, returning the plaint filed by the respondent number 1 herein came to be returned on the ground of non-compliance of Section 12A of the Commercial Codes Act 2015. They वापस पढ़ो. This appeal, this petition against the order dated 31/7/2024, returning the plaint on the ground of non-compliance of Section 12A of the Commercial Codes Act 2015, came to be disposed of with appropriate direction. Good point. The High Court, while disposing of the first appeal, all as under paragraphs 42, 43, 40, and 42, respectively. Okay? The petitioners, being dissatisfied with the impugned judgment and order passed by the High Court are here before us with the present petition. We heard Dr. Abhishek Banu Singhvi, the learned senior counsel, appearing for the petitioner. Original respondent number 1 before the High Court, and Mr. Gopal Subramaniam, learned senior counsel, appearing for the respondent number 1 hearing, original appellant before the High Court at length. Manifold contentions were sought to be raised in the course of the hearing. By both the sides. Good. Having heard the learned counsel appearing for the parties and having gone through the materials on record, we are of the view that this long drawn litigation between the parties, which is getting murkier and murkier day by day, could be brought to an end if parties are persuaded to go for mediation before a former judge of the site, before the former judge of the Supreme Court. More particularly considering the nature of the disputes between the parties and the stakes involved therein. Good point. The proposal put forward by us for mediation has been very graciously accepted by Dr. Abhishek Manu Singhvi and Mr. Gopal Subramanian. In such circumstances, we put we appoint somebody. Dr. Justice D.Y. Chandrachud, former Chief Justice of India, to act as a mediator between the parties and resolve the disputes. Full point. The fees, etc., of the learned mediator shall be fixed in consultation with the parties. The learned mediator shall furnish his report at the earliest. Okay? Parties to appear before the learned mediator and proceed further. This matter for appropriate directions after 8 weeks. Okay? In the meantime, both the parties are directed to maintain status. If there are any proceedings between the parties, civil or criminal, those proceedings shall remain stayed till the report of the mediator is received and further orders are passed by this. Okay?
Very well.
Shall proceed.
Deeply obliged. My Lord, just one more thing, my Lord. There are certain civil cases not filed by respondent number 1, but by some other group company, my Lord, against the petition.
We are sure now it will be resolved.
Very well, my Lord.
Fine? Something, it was little distant. Lordships, anyways.
Well, acute discernment.
Anyways, doesn't matter. Next time.
Deeply obliged.
नहीं अपनों respect. Rest of the matters we will post it in the next week. We have a separate bench, Lordship. Any mention?
44, service is incomplete vis-a-vis 2 respondents is concerned. So if they,
Let me request you all have to make it to the.
in the meanwhile, I'll do that.
Your Lordship, I'm mentioning item number 46, Your Lordship. It's an urgent matter, Your Lordship. NEETPG matter. Monday, Your Lordship. Lordship, top of the board will be.
Who is appearing for the other side?
Your Lordship, NB.
Who is appearing?
Vinay Sharma, Your Lordship.
Respondent, NBMS, Lordship.
This is the same matter where Mr. Rahul Kaushik.
Yes, Your Lordship. Yes, Lordship. Your Lordship, these are Rahul Kaushik says is a corrected matter.
Connect.
Main is the Aditi and others, and
We'll keep it on Tuesday, not Monday. Tuesday. Top of
My Lord.
illegal.
Arrest, my Lord. Yes, my Lord. Chinese woman has been arrested and 3-year-old child. Today the matters are listed, but it was not good.
You have served them.
Yes, my Lord.
Who is appearing?
I'm being well on ASG, Miss Bhati, Lordship.
Party has some instructions.
Yes, Lordship.
What are the instructions?
Previous order.
What are the instructions?
When I'll inform her, she'll be here, Lordship. After lunch.
But after lunch, we are not assembling.
Maybe on Monday, Lordship.
You asked Ms. Bhatti to be here on Monday. Monday,
Yes.
top of the board.
Yes, Lordship.
Monday.
We have your lordships.
1, 2, 3.
Item number 1.
Oblige will.
But
You have your lordship.
So there's one matter, serial number 41. It will be taken up on 17th October, if it's convenient.
17th,
October. Or next Friday also, I have no problem.
17th October.
Or next Friday, whatever is convenient.
Your petition case.
Department's
petition. Okay, we'll fix it.
Oblige.
Will lordship be item 37, my lord?
Yes, what do you want to mention?
My lord, item 37, can it be on 6th of October, my lord? I'll be coming to Delhi on that day, my lord.
Pardon?
Item 37, will be had on 6th of October, my lord?
6th of October?
Yes, my lord.
Okay, 6th October. Okay.
Oblige, my lord.